Thank you, Martha. Yeah, thanks guys for having me. I'm not going to have all the answers today. Um, I did, just sort of started talking about this topic on the No Kings Day that we had a couple months ago, and the turnout. Some of you were probably there. Was fantastic. It's inspiring. So I'm just going to try to give just a little taste of this because I'm not a constitutional law attorney. I'm just a criminal defense attorney. The Constitution is a big part of my practice. But this is my first time doing something like this. I very much appreciate the opportunity to do this, to talk to you guys, because I've got my outline, the first one I made on something like this. Maybe I can use it again at another event, another time. And I love the idea of this organization because I love the non-political nature of it. As Washington said about political parties, his foresight was they could tear our country apart. And I think there's some merit to it. And just things have become very political. Everything's political. And we need to all of us get back to like the heart of what we're all about, why we're here, what a society is about. And I try to use humor sometimes. It doesn't maybe always come across the best, but with that in mind, one of my favorite shows, if you say Friends, you have to leave right now.
So the purchase. See nothing with the purchase. Neither with the arrival, sir. Yeah, so the other time. Over there. There. Turn watch him. Nothing escalated. Purchase is in the lunch. Joey is right over there. It's much. Yeah. Sorry.
Living in a society, exactly. Somebody cuts us off in traffic. It's always their fault. It's always, why can't we be more civilized? There's always this sort of subjective view of the world. So what kind of society are we living in? Let's take a stanza. Oops.
So the purchase.
Types of society. So this is really basic. I'm going to jump into the Constitution, but we've got authoritarian societies. Those are societies that are characterized by a rejection of the plurality, use of a strong central power to preserve the political status quo, reductions in democracy, separation of powers, civil liberties, and the rule of law. Know where you want to live. Probably the best example right now, because you look at authoritarian, there's autocratic or oligarchic. Russia. Russia would be an example of an oligarch society. Not the place you want to live, not the place where the rule of law is respected. Then we've got totalitarian, even worse than authoritarian. The best example I can think of right now would be North Korea. One person completely controls, everything. Just reading from this, prohibits opposition. One person controls the public sphere, private sphere. Just no freedom. We've got a monarchy, which the people in this country are sort of familiar with because that's why we formed this country. Is we were being told by King George how to live, to pay taxes without representation. We didn't like that. And that's why we rebelled in 1776. So what do we have? And then the other form is democracy. We have sort of this hybrid democracy where political power rests in the people. Us, all of us. That's what it's all about. Is the power comes from us. It's also got a Republican form in the sense that we elect senators and congressmen. So we don't directly vote on every bill or every law. We elect representatives. That's what makes it a republic. Those people vote for us. So we live in a democratic republic, and part of a democratic republic is the Constitution. So Constitution and public law, the organic and fundamental law of a nation or state, which may be written or unwritten, establishing the character and conception of its government, laying the basic principles to which internal life is to be conformed, organizing government, regulating, distributing, and limiting the functions of different departments, and prescribing the extent and manner of the exercise of sovereign powers. Magna Carta was one of the first examples of this, I believe in like the 1200s, where the king had to first cede power to the people in the Magna Carta. that was an important step, and our founders took a note of that and based a lot of what we're about to learn about on the Magna Carta. One interesting concept, I'm about to talk about rights and freedoms and things like that. One thing that's important to remember, a sovereign has no rights. A sovereign can only give rights. And so that's the essential sort of part of the Constitution is it creates that boundary between the sovereign, which is the United States, and the people. And it gives us certain rights, and in particular, the first 10 amendments, the Bill of Rights. But it's, yeah, and this website I found really helpful when I was coming up with this. It very, I think, neutral, doesn't have a political leaning one way or the other. It was pretty helpful if you're curious. It had great annotation. So let's jump in here to the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. And as you might know, this was our second try. After the first attempt was the Articles of Confederation. I don't really talk about those a lot, but that was, it didn't work. It almost led to the dismantling of this country because it didn't create a strong central government. So we started off with the Articles of Confederation, which really gave the states too much power. And the problem was if you're raising an army, Virginia doesn't want to contribute to the army. Massachusetts does. There wasn't this central authority that we call federalism. Federalism is the idea that there's a sort of a triangle at top. That's the federal government. And then below that are your different regions. I think of France. I think France was probably one of the first sort of, well, now that I say that out loud, maybe France got it after us, but they have a very sort of federal idea in that the different regions are empowered in their region to do what they want. So you can, there's different cultures. You can have different cultures based on different areas of the country, but everybody reports to the top. That's essentially federalism. That's what this country is based on. So hopefully this isn't too boring. When I was doing this, I learned a lot. There's some interesting stuff in here, but there's also some kind of droll, legal stuff, all legislative powers. So first three articles, this is Article 1, 3 branches of government, separation of powers. We don't want power to be vested in one person, one branch of government. So the first 3 articles lay that out. In the first article, it talks about our legislative branch, Congress, which shall consist of a Senate and House of Representatives. This is just, I went through the sections. I don't want to go through it all. I just tried to take out the important stuff. The second section, you had to be 25 years old to be I believe that is for the House. You had to be 25 years old, 7 years a citizen of the United States and a resident of that state. To be a senator, you had to be, you got 2 from each state, had to be 35 years old, had to be 9 years a resident of the state. Vice president breaks a tie. If the House or Senate have a 50-50 tie, the vice president would break that tie. The Senate has jurisdiction to try impeachments. Still, some of this, as I'll go through, you'll see, has been modified over the years, but some of this is still the case with, for example, the impeachments. The Senate still, as we know from Clinton and Trump, the impeachment hearings are heard in the Senate and are presided over by the chief Supreme Court judge. Need 2/3 of the Senate to convict. States decide the time, place, and manner of electing senators. Congress can pass laws that can change every one of those except the place. So Congress can say, Colorado elections are going to be held in Nevada. That's written in the Constitution. They can't mess with the place. They can change the time. They could change it to any day or month of the year, but it has to be in that state. House is the judge of elections. So if there's an election dispute, which 2000 we had. Sometimes when I talk out loud about this stuff, I realize I want to know more about what I'm talking about because there are interesting things. I remember that being settled in the Supreme Court. I don't remember Congress necessarily, the House necessarily resolving that dispute. But again, people have written books. I mean, you could take each one of these sections, and there's people who've written, hundreds of books on each section. This is just sort of, the overview. For any Gen Xers out there, number 7, how a bill becomes a law. We all remember that. You know, the little bill on the courthouse step or the steps, you know, during your Saturday morning cartoons. Congress has the power to tax, pay debts, borrow money, regulate commerce. So I underlined this, another sort of digression I could go off on that I remember from law school. The Commerce Clause is probably one of the most powerful tools the federal government has to control the states. This is the only mention of it in the Constitution. Is this little line right here? That little line has mushroomed into an ability for the federal government to regulate everything because we're a capitalist country and everything sort of goes in commerce. And so if anything affects commerce, the federal government says we get to decide. So there was a footnote in an opinion, it was like footnote 5 in some opinion from like 100 years ago where this started, where they mentioned the Commerce Clause. And it's grown since then. And so you'll see this as I'm going through this. It's really fascinating, sort of from a historical point of view, how, you know, where we started and where we are today. And it's why I take issue maybe with people who say Constitution's originalist. I'm not trying to be partisan, but originalists who say, you know, everything is, you know, black and white and it's how it was written then. I mean, that's the antithesis of a constitution. A constitution grows, it adapts, it changes with the time. You know, the framework stays, but you know, it changes. And so this Commerce Clause, which is just kind of an afterthought, is now, if you read an opinion in a federal district court, Supreme Court, the reason they were able to take the case is because whatever the issue was affected commerce. It affected commerce between the states. I mean, you can argue everything affects commerce between the states. So it's interesting to see how that little thing sort of just blew up. Foreign nation, naturalization, coin money, make post offices, make courts, declare war, raise armies, navies, you know, that makes sense. That's what we want, you know, our federal government to do. Sections 9 through 10, this was interesting. I never realized this until I started preparing to this, that they actually put a date in the Constitution. As you know, we probably know, if that original sin of slavery was sort of baked into our Constitution. And there was obviously a dispute when they were writing this in 1787 about slavery. And the agreement that looks like they came to is, we're not going to mess with slavery until 1808. Basically, you know, we'll let the southern states slide. We'll let them do their slavery thing. But on 1808, Congress can start controlling slavery. And I think around that time is when we stopped importing slaves. And basically, slavery continued, but it was based off people who were still here. Habeas corpus, which I'm going to get into in a little, cannot be suspended unless when in cases of rebellion or invasion, where the public safety may require. You know, a vague term, if you want power, if you're a president, you know, what do you say? I mean, there's a rebellion going on. There's, you know, people are invading. We're in trouble. I need to invoke habeas corpus. That's how I'm going to get my power. You know, and maybe that's a cynical way of looking at it from today's point of view. Let's not forget Lincoln invoked habeas corpus during the Civil War. Seems a little more valid maybe than presidents who might say we need to invoke it today under, you know, in my opinion, different circumstances. No bill of attainder, ex post facto law. I had to look up bill of attainder. Bill of attainder is basically when you outlaw a certain group. I've got some notes here. When you punish a group of people or persons without trial. So basically, you just say these people, this act, all of these people are guilty without a trial. Ex post facto is passing a law that is retroactive. So, you know, passing a law that says, for example, people born in this country are no longer citizens of this country. You can't do that. You can't pass a law that's retroactive. Most laws are prospective, especially in the criminal world. I think, you know, yeah, I'm not going to digress because again, people smarter than me probably know the nuances a little better. No title of nobility. Obviously, we started this country because we did not like kings. We didn't like nobles telling us what to do. States can't tax each other. State can't make ports and charge each other. So, Virginia couldn't tax South Carolina for transporting cotton to it. You can't tax each other. The only charge that you could put on another state is for, let's see, it's, yes, yeah. Sometimes I can't even read it, but yeah, it's for, now I can't see it, but basically to run the business, to run the business of processing all that. States can't make treaties with other countries. They can't print money. They can't collect duties. They can't keep ships or troops of war. They can't engage in war. And an interesting little thing here, unless invaded or in such imminent danger as will not admit delay. So if one state's invaded, can that state declare war? I don't know. It's probably somebody smarter than me knows the answer to
What
this.
is invasion to that?
Right.
What does that mean?
Right. It's then, and that's, when I was thinking about this and writing this, I mean, that's why I mean it. I love organizations like this, and I love, these things develop over time. We've got to, these things need to get answered. They're vague, and how do we get them answered? And, conflict, sometimes, I'm an attorney. I don't mind conflict. I think conflict can be really, really good. I mean, it can. People sometimes are like, I don't like conflict. Let's all just get along. And it's like, conflict can make things better. It can clarify. And that's the one thing I would say. I'm not trying not to make this partisan, but what our president is doing now is essentially, in my opinion, a stress test of the Constitution. And it's really scary when you're in it and you see it and it's happening. But, 200 years from now, they might look back on this time and there might be answers to questions that we don't have right now. And the reason, we got those answers is because we went through this really stressful, hard time where we had a president who's trying to exploit all these things that are vague or unknown. And so, that's conflict can be good. Conflict can be really a positive thing because it can produce a good result.
Part of the digression, back to the emoluments.
Right.
Okay, it says, legislator not have a civil position or set emoluments. How does that differ from lobbying as far as like?
Well, because lobbyists aren't elected, they don't work for the government, right? Is that?
No, I'm thinking about the purchase.
Oh. Yeah. Yeah. Well, aren't they supposed to report gifts and stuff like that? It's
Figure, they don't have to, then after a certain figure, they're supposed to.
right.
Right, that's just gone out the window.
Yeah, I mean,
Right.
corruption, that's there. I think about, the 70s. I mean, I was a kid then, but a lot of good stuff came out after the Nixon years. There was a lot of reform. There was a lot of cleaning up that happened because of that sort of corruption. So again, I think when we're in it, it can be terrifying at times to see sort of how people in power manipulate the government. But I just, there's hope that, if we can continue and stay strong and exist, that we can lay the foundation for, our children, our grandchildren, and make, fix these things that this are being stressed right now. And so, who knows, 10 years from now, maybe, we will have stricter lobbying laws or things like that. I don't know. So this case just came out. I thought this was going to be, so habeas corpus is basically saying, you're asking the court to review an unlawful detention or imprisonment of an individual, requesting individual's custodian to bring the prisoner to court to determine whether the detention is lawful. This case just came out as I was preparing this on Thursday. This is Bennett versus Francis, Southern District of New York, federal court. So on July 18th, Bennett filed a writ of habeas corpus challenging the lawfulness of his detention by ICE. As I was talking to Jan about, you might have seen the videos of New York Immigration Court, the ICE guys all standing on the side, people doing what they're supposed to do, by the way, go to court. That's going to court, knowing you might be arrested, still going to court. I mean, I very much respect that. I think it would be easy for any of us to say, there's no way in hell I'm going to court, I'm gonna get arrested. But these people are doing what they're supposed to do. They're reporting to court and they're getting arrested. That's what happened to Bennett. Benitez, he was, so he came into the country, fled Paraguay, seeking protection from persecution, was arrested at the border and released, as many immigrants are seeking asylum. You're released, you're given a new court date, and again, you come back on that court date. You love this, you want to live in this country, you want to follow the rules, you want to do everything right. Come back to court on this day, and he got arrested. He was a construction worker in Queens, stayed out of trouble, had his two sisters, got arrested. So what happened was, apparently ICE can detain you either, there's, I can't think of a better word for it, but discretionary and, non-discretionary automatic detention. And I think that applies more when you're not in the country. And so he was in the country, at this point legally, his asylum petition was pending. So his detention was discretionary. It wasn't automatic that he had to be detained. It was discretionary. And so ICE, in their, sort of overzealousness, just, is kind of rounding people up and not giving them hearings and not treating them as individuals. So, that's one of a big thing you will see in the law. Part of due process is, you need to evaluate everybody's circumstances, every individual circumstance. You can't just blanketly say, you're charged with a crime, therefore, you get this. You have to use sort of a totality of the circumstances, treat everybody based on their individual circumstances. And so ICE didn't do that. They held this person, and they were not using their discretion. And so what this federal judge said is, because you were not using their discretion, because you didn't give him any process, you didn't even consider his individual circumstances, you just detained him because he's seeking asylum, you can't do that. You've got to give him some sort of process. And Mr. Benavidez was entitled to more process than he received. They balanced the individual's interest with the government's interest and found he should be released immediately, and ordered him. I believe he is right now, and he was transported out of New York. He is now being transported back to New York, and I believe he is going to be released tomorrow. So there's habeas corpus doing what it's supposed to do.
Brian, quick question. What's really important to me that I'm reading up there is due process clause applies to non-citizens.
Right.
There are a number of people who feel that it's only for citizens.
Right.
And what is that, the Fifth Amendment?
5th and 14th.
Fifth and
Yeah.
and we need to shout that out loud, because it's just misinformation from one side or another.
Right.
It feels really strongly that that's for citizens only.
The idea is the rule of law applies within our borders. So it doesn't, it doesn't matter who you are, how you got here. Once you're in our borders, the rule of law applies. So yeah, it's not, you maybe don't have the exact same rights, but due process is not forfeited. Once you're in this country. Yeah, absolutely. It applies to everybody.
Is habeas corpus due process, are those two different things?
So a lot of these topics do sort of go together. And part of habeas is you're entitled to due process. And so, that's a good question. I don't know how exactly to answer that. Habeas is the idea that if, I'll just tell you about a case I had real quick. I had a client who, he was on parole. He was charged with a new crime, but in the new crime, he got bail. And when you're on parole, you're entitled to a hearing within 60 days. He didn't get a hearing within 60 days. So I served the Attorney General, asked the court to grant him a hearing because he was being held illegally. And the judge granted it. My client got out because he had not had a parole hearing in time. So I think it's more, so I don't know. I don't know if that answers the question. Due process is I guess due process sort of touches everything. So I would say, yeah, due process is sort of part of habeas, but habeas is specifically, if somebody's holding you, you're in a jail, you have the right to say, I'm challenging that detention. I'm challenging why I'm being held.
Well, what you have for the definition up there says it's a court jurisdiction to review.
Right.
Is that what due process? See, to me, that's just a very vague.
Yeah, due process is different from jurisdiction. A jurisdiction, it's basically, so you can't, if you're held illegally, you have the right to challenge it. That's the jurisdiction. So if I'm being held, I have the right to challenge my detention. Due process is more, I guess maybe the details of how that how that works. So,
Well, I mean, could the administration say, well, we give him due process, we brought him in and we saw he had tattoos and that's the due process, and now we decided he.
they could. I
that
mean,
would be
as long as you got a
process?
hearing, that's all habeas requires.
So anybody can do the hearing?
Well, a court, a judge.
Oh,
Yeah.
that's what I meant.
I mean,
So
all
due
habeas really,
process
yeah, it's saying,
Says requires the court.
it requires, you know, a minimal process of, yeah, fairness. I mean, that's a really good question, and well, I don't think, I think if you're at, you know, an asylum seeker, no, it's immigration court. They, you know, because even though due process applies, it's a lower standard. That's what happened to, Benitez, is he didn't get any process. They just basically went, you're here legally, we're not gonna give you a process. So we as citizens would have a better process, but even if you're not a citizen, you get some process, and he didn't get any.
I think one way to maybe look at it is most due process is already codified in law. So it's not something that you can just come up with, you know, there's an immigration court, there's a due process for an immigration court that is usually codified in law, not just somebody came up with it off the top of their head.
Okay, so there's a history of laws that have been passed.
Yeah.
That give precedent of what due process means for an asylum seeker.
That would be my.
I appreciate that. No, and that law was not followed in his case, because asylum seekers should be given, because their detention is discretionary. He was not given any discretion, so. Go ahead, Martha.
I was understood that if the due process is your rights if you get arrested, and it includes things like the right to an attorney, the Miranda thing, you have a right to take it to court, because if you have an attorney, that's where it's probably gonna go.
We'll get to that. That's not,
Different thing.
okay, yeah.
Habeas corpus is just, if the due process doesn't happen, they can't send you to jail. That to me has always been the difference between.
Yeah. And these are esoteric questions, and I'm starting to sweat a lot, because I mean, I really, there's constitutional law professors who can talk about this way more eloquently than me, and seriously, books have been written about this, so, I mean, and that's the thing, I talk and I hear questions, I'm like, I have the same question, I don't know, but that's that's, you know, to give you an insight to law, that's sort of how the law works, it's case law, is you try to find cases where a similar situation has happened, and you try to analogize it to your situation. So the first thing you would do is in your client situation would be like, okay, well, what do other people get hearings? Let me find a case and start, and that's how it's solved.
I've got just one quick question. Can someone be detained, arrested, and it's 60 days before they may be served due process?
I think so. Yeah. I mean, like if my client is on parole.
Right.
Or like some people's hearings aren't scheduled until like 2029 because they've gotten rid of like so many judges and so many like people that they're just inundated with.
Oh, boy.
cases.
But they're getting some process. The Mr. Benavidez didn't get, or Benitez didn't get any process. So yeah, it might help too. Yeah, some of these might be answered with some of the next
Well,
section.
No. Few questions. So going back to the Constitution, I feel like this climate that we're in right now is like, would there be any legal grounds for us to say, hey, this administration, it seems to be putting a group of people, immigrants, as, you know, to where it would go against that like group of people, like you can't declare, you know, all this group of people is not.
I mean, I think about Abrego Garcia, you know, when I first did the No Kings speech, that was my main motivation. I mean, that person was taken from this country without any due process. And I'm happy to stand here today and say he came back, you know, that's really important. And so he did. So there is some process. I mean, you can't, you know, there is, you can't do that. I mean, there's gotta be, because that's what happened to Abrego Garcia. He just got whisked away in the middle of the night, and the court said, no, you can't do that. no, you need to bring him back, and they brought him back.
And the horrible conditions that,
Yeah,
and the torture,
yeah,
allowable? I mean,
it's not within these boundaries, so.
That seems to set a precedent for the ICE to be prevented from doing this all over the country. Is that possible?
It's a good first step. It's a good, I had some lawyers I'm talking with in, some like fancy New York attorneys that I'm sort of hooked up with are really, that's the reason I put this up here. They're very happy about this. It's one of the first cases that's starting to turn the tide. And so maybe, you know, who knows though? I mean, this is not a Supreme Court case. It's not even a, circuit court case, which would be the next step. So, you know, it tends to be a pretty liberal jurisdiction. I think it would survive if it went up to the circuit, but then what would the Supreme Court do? I don't know. Yeah, I don't know. Okay, so now, yeah, let's talk about, president. This is Article 2, 4-year term. States appoint electors commensurate with the members of Congress. You have to be 35, natural born citizen. I thought this was very important. The oath or affirmation. I do solemnly swear that I will faithfully execute the office of the President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution. Constitution's above the President. You know, nobody's above the Constitution. Constitution is the top, and even the President is below the Constitution, and his duty is not to himself, it's to the Constitution. He's the commander-in-chief. He can make treaties that 2/3 of the Senate agrees, appoints ambassadors, Supreme Court judges, all other offices. But Congress could create inferior offices. So a good example of that is you've got Title III judges, Article 3 judges, which I'll get through next. They're directly in the Constitution, but for example, here in Durango, we have Magistrate Candelaria. He's not an Article 3 judge. He is one of those judges who is appointed by Congress. And so the worry is Congress can, you know, kind of mess with those judges that are not Article 3 judges. President gets to do a State of the Union, and he can be removed from office for conviction of treason, bribery, other high crimes and misdemeanors. As we know from the Clinton years, that's kind of vague. We don't know exactly what those are. Article 3, this is the judicial branch, so the third branch of government. So be vested in the Supreme Court and in inferior courts created by Congress. Judicial power extends to all cases in law, equity arising under the Constitution, laws of the United States, and treaties, jurisdictions over controversies in which the U.S. is a party. So remember, I was talking about the Commerce Clause. That's how the Supreme Court sort of gets jurisdiction, because if it involves commerce, then the U.S. is a party. Between two states, between the state and the citizen, between citizens of different states, a trial for crimes, except for impeachment shall be by a jury in a state where the crime committed. It also defines treason. I didn't put the definition in there, but interestingly, you need 2 witnesses or a confession. That seems kind of old school. Yeah. I don't know. Yeah, I don't know if that went on. Some of this has been modified. So this is a case. You know, legal scholars can wax poetically on and on about this case. This is a brilliant case. It sort of gets you fired up, because I still remember learning about it in law school and just sort of like, you know, kind of tearing up a little or something, because it's just brilliant. And it's why, you know, we need good leaders. We need smart people. You know, it's not just you know, we want to just say it's this piece of paper, it's the Constitution, but, you know, what also makes this country is a great country is we have these great leaders, really thoughtful, smart people, who are really wise. And so what happened is, and I just, you know, this is a really important case, so I just want to sort of describe it. So there's a rivalry, you all may have heard about that, the rivalry between Adams and Jefferson. You know, the thing about what was it? Adams was on his deathbed. He said Jefferson lives. They both, I think, died on the 4th of July at the same time. I mean, their history is so intertwined in our country. It's fascinating. These two guys who were just competing. You know, Jefferson was more of an agricultural guy, and Adams was more of a federalist. And their competition just shaped this country. They became friends later in life, but Jefferson. Let's see. So Jefferson beat Adams. Jefferson beat Adams in the election, I guess, of 1802, maybe. But before, as power people, presidents like to do, use their power as much as they can. Um, Adams said, I'm going to appoint a bunch of people, even though Jefferson's about to become president in like 2 or 3 days. I'm going to use the power I still have, and I'm going to appoint all these people, all these judges before the deadline, before I leave office. And the Senate approved it. Said, okay, this person can have a judgeship. Basically he's trying to pack the courts with his people before Jefferson comes in. And they don't get, everybody doesn't make it. Everybody doesn't get in time. And one of those people was Marbury. Marbury was not confirmed, or he was confirmed, but he wasn't delivered before the deadline. I'm not exactly sure what that means, but so Marbury sued. He sued Madison, who was the Secretary of the State, and saying, I'm supposed to have that judgeship. When he appointed me, he was still the president. And that's supposed to be my judgeship. And there was an act, a judicial act, of 1789 that said Congress could appoint those people, and so everything was valid. So goes to John Marshall, the Supreme Court judge, and in this very what's the Solomon-esque decision, he decides that Madison was wrong. Madison was wrong to not let Marbury have his job. Madison was wrong to do that, but that the law that Adams was using was unconstitutional. So it's just, and I'm not doing it service. I mean, it's just this brilliant way of taking power and giving power, at the same time. So basically he's saying, you were wrong not to let him become a judge, but the authority that you used to let him become a judge came from Congress, and Congress didn't have the authority to give you that power. It's brilliant. And because he's sort of giving and taking, and he's using his power, but he's using it in a really deft way. And that's the heart of what a good judge should do, right? I mean, and it almost tells us, why we need a judicial branch and why we need good judges, because they can sort of make these really difficult things. And I mean, it's political too, let's be honest. I mean, it's kind of a political decision, but it was a really interesting way of sort of taking power. So he sort of takes power from Congress, says you guys are wrong, but the heart of the issue is it established judicial review. That's the whole point of it all. It established the rule that judges get to decide what's constitutional. Judge Marshall decided this act of Congress was not constitutional. Had it been, Madison would have been wrong, but it's not constitutional. And so it basically, he got power. He used it to get the judicial branch's power, the power of judicial review. And so that power that exists today that, did come up in Abrego Garcia and was tested by Trump when the Supreme Court said you need to bring that guy back. And, Trump did. So fortunately, we still got judicial review. It's still there. Okay, Article 4. So I kind of go through these. So those were the first 3 branches. Full faith and credit clause. That just means states have to sort of treat each other equally. You can't treat different state citizens differently. You can't, somebody who's from whatever, Texas, you can't, take away their rights if they're in Colorado, treat them differently. We're all sort of treated the same. New states may be admitted by Congress. Congress did control the territories. That led to the Civil War because there was a fight in Congress over the new territories, whether they're going to be slave states or not. And it guarantees every state a Republican form of government, protection from invasion, and with the state's request from domestic violence. I thought that was interesting. So I think that might have been what was going on in Texas recently when Governor Abbott requested the Border Patrol or whatever it was, the National Guard to come in and help. I think that was the theory that he was going after, that as a governor of a state, you can then request federal help. And we're going to talk about the DC stuff. That stuff's really interesting. That's going on right now. Article 5, you can amend the Constitution, 2/3 of Congress. Article 6 and 7, let's see, debts from the Articles of Confederation, the prior government that didn't work out do apply to the US. That was important for, maintaining our cred across the world. We didn't want to start, we owed a bunch of money to France. Wouldn't have been cool if we just declared a new country and said, hey, sorry, France, we're not going to pay you now. We just started a new government. So we needed to establish some credibility. And so we said, you know what, if the previous government owed a debt, we're going to take on that debt. That was essentially a political decision because that way France would support us. Judges and states are bound by the Constitution. And of course, a country that was founded on religious freedom specifically has this line in here, but no religious test shall ever be required as a qualification to any office of public trust under the United States. Interesting. Okay, this is the most subjective part. This is my indulgent part. I'll be really quick. I had to put this in there. All this stuff is pretty dry to the point. John Stuart Mill is my favorite philosopher. So I have to put this in here. I'll be real quick. Utilitarianism. I love it. Learned about this in a political science undergrad. And it does apply to this topic because it is where we came up with standards of review. I didn't know where else to put this, but when a court is reviewing a case, they have a standard to review the case. So and to me, that was John Stuart Mill using utilitarianism, which is basically the idea, if it benefits the most, but it does the least harm to a minority, that's sort of the goal of government. And so the idea with the standards of review is, if you're going to mess with something that a minority, something that's immutable, which is a whole nother thing I realized, is religion immutable? I don't think so. And that's really interesting. This country was founded, it puts religion in there. All these other things are sort of immutable. We can't control our skin color. We can't control our gender. We can't control, where we were born, things like that. That makes sense. You don't want to discriminate against people based on things we can't control, but you can't discriminate based on religion. That just goes back to our founding fathers, because for them, it was a really big deal. That's why they fled England. That's why they fled Amsterdam, was for religious freedom. So this one characteristic that's not immutable is in there. And so if you're messing with those characteristics, the government law has to pass strict scrutiny. So if you're going to discriminate against somebody because of their gender, because of their race, because of their religion, that law has to pass strict scrutiny. It has to, it's a really high test. It's got to basically be a damn good reason to pass that law if you're going to mess with some of those characteristics. Then there's intermediate scrutiny. So, a little less, and that applies to sort of equal protection situations. Where you're, and when I was representing the homeless, I filed some briefs in municipal court, equal protection was my argument, that the homeless were being discriminated against, because they were not being treated the same as, people who were not homeless. And I got to use this intermediate scrutiny standard because I was alleging an equal protection violation. So I didn't get the highest standard. I didn't get the lowest standard. I got this medium standard. I still lost, but that was my argument. And so that's sort of a middle ground, and that's more when equal protection comes in. So if the government's passing a law and it doesn't discriminate, doesn't pick on something that's immutable, then it just has to be a rational basis. So is there a rational basis for this law? If it's not, impacting a minority, not hurting a certain group, it's easier to pass that law. Most laws are passed that way under a rational basis test. So I had to put that in. Now back to, here's the fun stuff. This is where we get fun stuff, not just attorney nerds. It really is. It's fun. Bill of Rights, man. First 10 amendments to the Constitution, passed the same time as the Constitution. Because remember, we got this sovereign, we got this Constitution, and immediately we got to have these first 10 amendments to help the people, to help all of us. So this sovereign does not run amok all over us. And of course, the biggest, most important, please indulge my humor. And I realize I'm in a VFW. Walter's maybe not the best example of a vet, but we all know this person. We all know this person who is an expert on the First Amendment. I'm going to skip the first part.
Jesus Christ. Well, the point is, Walter, another to kill me. Dude. That's just the stress talking, man. Now, so far, we have what appears to me to be a series of victimless problems.
Excuse me, sir. Please keep your voices down. This is a family restaurant.
Oh, please, dear. For your information, the Supreme Court has roundly rejected prior restrictions.
If you don't come, ask you to leave.
Lady, I think the money should go to some staff in the box so that you and I can control this family restaurant. They do, you go away, man, but this affects all of us, man. They're basic freedoms.
All right. We all know somebody like Walter, right? Somebody who, everything's the First Amendment. Everything's like, hey, I can say that, I can do that, First Amendment. Most people are like Walter. They're way off topic. They're not, it's fun to talk about. It's fun to rant about, but, Walter's not making any sense there. That's not a First Amendment issue. First Amendment doesn't apply in a cafe. Same time as the Constitution, 1787. Yep. So, these great rights, 5 important rights. Congress shall make no law respecting an establishment of religion, prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for redress of grievances. 5 very important freedoms, right there. First Amendment, first one that comes out. Interestingly, there's legal scholars kind of go back and forth on the freedom. Is the freedom of religion protecting the government from religion, or is it protecting religion from the government? Sort of one of those like yin yang things. I don't know if there's an answer to it, but the idea is these two are not supposed to be together. Religion should not be impacting the government. The government should not be impacting religion. And so now this is the law. This is what attorneys do. I'm going to kind of tell you guys about some cases. Hopefully it's not too boring, but I think it's one of the best ways to explain the First Amendment. So, and what's really interesting is how this stuff is developed. I mean, that's the thing. It's just, that's again, I talk about conflict and I talk about, I don't know how else to say that, not fights, but just, that's how we learn. That's how we grow. That's how, we get better is we challenge things. We try to, that's how you bring out the best of society. Little digression here, but I always hear people talking about community. And it's interesting. I hear people say that word. It always sounds like it's their community. People who share like their values, their little specific things. You know what a strong community is? It's one that tolerates different values. It's not a community where everybody gets along and everybody has the same, agreement. It's a strong community is one where we tolerate differences. That's what makes a strong community. And that's what's great, seriously, about this organization is, you can be a conservative, you can be a liberal, you can join this organization because that's how we get stronger. It's not by surrounding ourselves by people who are like us. It's by, it's by having different ideas. So freedom of religion cases, Reynolds versus the United States. I'm going to assume this had, probably in Missouri, because I think that's where the Mormons ran into some trouble before they went to Utah. There was an anti-bigamy statute. And so here we go. We got these two things in the First Amendment. I got freedom of religion, but I've also got, let's see. Now I'm lost my train of thought here. So maybe there's not two conflicting ones there, but the idea was, the idea is how strong is that freedom? Is my freedom of religion, does it overcome the state? Does my religion, just as I practice this religion means I don't have to listen to the government, I don't have to listen to the state. And this decision said, no, your religion doesn't trump everything. Just because your religion says you get to marry more than one person, the US is saying it's a crime to marry more than one person. And so a criminal law trumps basically your religious rights. And that was a sort of one of the first challenges to religious freedom.
Would there ever be a time where the state can say, we allowed this in our state, but the government comes in and says you can?
Right,
Would that be
that happens a lot, yeah. Where a state statute would be declared unconstitutional because it violates the federal constitution. So yeah, like Utah can say, yeah, we're pro polygamy, and then the federal government would file a lawsuit and say, no, you can't do that.
How does that go with the First Amendment? I mean, how does that reconcile with freedom of religion?
It's not an unlimited freedom. It's the Constitution prevails. I mean,
If your religion says you get to own people.
Right.
Then work.
Well, yeah, I see the
I
distinction.
think it's the crime part's important. If your religion advocates for something that's a crime, no. You know, that's sort of one of the first bright lines. Your religion can't advocate for a crime.
Bad idea.
Lemon versus Kurtzman, that came up with a really important test that is then used in other cases. That's where, Pennsylvania law reimbursing religious schools with state funds for textbooks. So you've got a religious school, but taxpayer monies is paying for the textbooks. Whether that violates the Establishment Clause of the First Amendment, 8-0 decision, the court set out a 3-pronged test. To determine whether a statute is constitutional, it has to have primarily a secular purpose. Its principle neither aids nor inhibits religion, and the government and religion are not excessively entangled. So that's, again, we're getting the nuance. That's sort of the conflict, you know. So we've got these ideas. Yeah, we get free religion. Well, it's not that simple. What if, you know, so now the courts, things are getting a little more nuanced. You know, similar with Wisconsin v. Yoder. There was the Amish did not want to send their kids to school after age 14. Wisconsin had a law that said you have to come to school until you're 16. In that case, religion won. The state's interest in having students attend 2 additional years of school did not outweigh the individual's right to free exercise of religion. So their religion wins. You know, what's the difference? I don't know. It's nuanced, and it's, you know, Stone v. Graham, the court considered whether a Kentucky law mandating the display of the 10 Commandments violated the Establishment Clause. The court found in 5-4, and I put the 5-4 stuff's important because, again, we want to believe like this is all just kind of like what I maybe fell prey to at Marbury versus Madison. You know, these are smart people making just the right decision. It's not. It's political, right? I mean, whether this is a law or not is a 5-4 decision. You get one different Supreme Court judge, bam, it's a different rule. So, you know, politics, it affects everything, even this, you know, supposedly higher than, you know, holy judicial branch. Politics affects it. You know, had you had one different judge, that wouldn't be the case.
But that was a 1980
Yeah.
case.
Yep.
Didn't we just have a state that again did that?
You're right, and I think, well, Oklahoma, maybe. I think, yeah, Oklahoma, I think.
Louisiana.
Yeah, I think a couple states.
Just posted.
Yeah. I think a couple of states were trying, so I don't know, I don't know the answer, but so it's this stress test again, you know? So this case is being challenged, and I don't know the specific answer to that, but, yeah, it's not, you know, written in blood. Wait till we get to Roe versus Wade. Yeah.
Oh, boy.
Freedom of speech cases. Okay, this is the fun part, you know, and I'm not trying to, whatever, be a jerk, but, you know, as a defense attorney, one of my favorite words is the F word. It's brilliant. It can be a noun, it can be a verb, it can be an adjective, and I mean it. I think it's a big part of this country that you get to say things that maybe aren't nice, maybe aren't polite, but it's part of our right as a citizen. So this is interesting. So 1919, you know, we've got World War I, you know, a great socialist, Eugene Debs, would go around passing out leaflets saying, you know, you can ignore military recruitment, you know, basically trying to undermine the war, anti-war speech. His speech and Schneck's speech were found unconstitutional. Today, you can do that. Back in 1919, the court said, nope, it presents a clear and present danger that it will bring out the evils Congress has a right to prevent. This is where the famous line that you might have heard about, you can't shout fire in a crowded theater, comes from. So basically the court is saying, you know, these radicals, these socialists are trying to undermine the war effort, and that creates a clear and present danger. You can't do that. But things are slowly starting to evolve. Chaplinsky versus New Hampshire. He's distributing Jehovah's Witness literature and called the town marshal a goddamn racketeer and a damn fascist. He was on a public street. You'd think that today that type of language would be protected. 1942, the court said it did not protect fighting words. Fighting words are something that have been, are almost disappearing. They're almost disappearing. You can pretty much say anything nowadays, and courts are incredibly reluctant to find words unconstitutional. There was a recent Colorado Supreme Court case where somebody was using homophobic slurs and things like that. I'm not condoning this. I'm not saying that's okay, but the court said that's not fighting words. You know, you can use those words. Okay, so things are starting to get better in the 60s. Tinker versus Des Moines. Students wore black armbands. That was to represent their support for a truce in the Vietnam War. The school sent them home. The court, they then challenged that. The court said students wearing armbands to protest the Vietnam War was pure speech, protected by the First Amendment. So this is where the Warren Court comes in. You know, the Warren Court, for good or bad, is responsible for a lot of the leaps in, I guess, in my opinion, in society that, you know, we sort of come to expect today. If you're conservative, you don't view the Warren Court the same way. You see them as sort of a agenda-driven court. But you'll notice a lot of these important cases come up in the 60s. Then we have Brandenburg versus Ohio. He gave a speech advocating for violence at a Ku Klux Klan rally. The court said the First and 14th protect that speech because it didn't call for imminent lawful action. One of my favorite cases, Cohen versus California. Cohen goes to court. He's in the courtroom and he's wearing a jacket that says, "Fuck the draft, stop the war." He gets a policeman, sees him in the courtroom, pulls him out, charges him with the crime. The court said, "Nope, you can do that. You can say, you can wear a shirt that says, you know, fuck the draft. One man's vulgarity is another's lyric." Miller versus California, he sent out a mass mailing advertising adult materials. He was charged under a law prohibiting obscenity. So he lost because it was obscenity. I think obscenity, the definition has changed, but at that time, you could prosecute obscenity. But then we have this other case from 1982, Island Trees, they banned books. Okay, so this is a book banning, something going on today. You know, we still have this issue. They were banning books that were anti-American, anti-Christian, anti-Semitic, and just plain filthy. Supreme Court said you can't remove books from school libraries because they disagree with the content of the book's messages. School libraries enjoy a special affinity with the rights of free speech in the press.
So Brian, I'm listening to all of these and the decisions. Do they become a precedent or are they just totally ignored any year past that?
They're precedent. They're precedent.
But it's not working.
Well, so the thing is, it's the nuance. It is. That's the problem with this, and that's sort of maybe the problem with this presentation. Is I'm glossing over stuff. I mean, you got to read the cases. You got to kind of look at the nuance. The way the courts will distinguish facts. You know, so if there's any difference in the facts, they'll say, "Oh, well, that's different. That's different than that case because you know the facts are a little different." And I mean, I don't, you know, some of these book banning cases, I don't know that they have gone to the Supreme Court. I mean, we have heard about some of them, but maybe they're on their way there. I don't know. But this is precedent. It's as far as I know.
It's also why they're practicing attorneys. Because the law is an interpretation. Because they're not precedents, and then you interpret that. And that's what the judges do. They have to interpret what's in there. So it's a personal opinion about what.
One of the first things I remember from law school, you know, you go in, you're sort of naive, you know, whatever, big-eyed, and just in my first year realizing it's just bullshit. I mean, I'm sorry, but a lot of it is just how they write their opinion, and it's not. I'm sorry. It's not. It's just, it's not entirely 100% logic. I mean, you know,
That's why it's an appeals process.
yeah, but then you get to the Supreme Court and you want to think these guys are, you know, how does Roe versus Wade get overturned? I mean, I thought that was precedent.
Right.
But you get it, it's political, guys. I mean, it is. It's, and that's sort of, I mean, I guess it hurts a little, you know, because we want to think we want to believe that everything's, you know, black and white and you can't change stuff. But guys, I mean, you can pack a court with judges who disagree, and they're going to find a nice little way to word it, make it sound like their decision is completely logical, and it's not. I mean, it's just, it's unfortunate. You know, Texas versus Johnson, you can burn flags. Then we get into like the Decency Act. They tried to regulate speech over the internet. And that was overturned because it was indecent speech. So there's a difference between indecent speech and obscene speech. You can regulate obscene speech, but not indecent speech. Yeah, it was right. Yeah, I'm trying, hopefully you guys don't leave this just like all demoralized or something. Yeah, there's some beauty in here, there is.
Can we get to that part?
And ebbs and flows. So freedom of the press, this is the one, that ruled that, you can't, allow for malicious, scandalous, defamatory, that law, is in violation of freedom of the press. New York Times versus Sullivan. This is the one you hear about, if you're a public figure, people can write and talk crap about you. If you're a public figure, you have to show that, there's the actual malice when you're, our president right now loves to sue papers for what they say about him. And I think, because he's a public figure, he's got sort of an uphill battle. He's got to show actual malice. Although scarily, some people are settling with him. Maybe they're afraid that he'd be able to show actual malice.
Is a public figure elected?
That's a
Not
good question.
necessarily.
It's pretty low standard. I mean, just any, your name's your county commissioner, you're a mayor. I mean, public figure's pretty broad. So
Hollywood stars.
yeah, yeah,
Mm.
They're not.
yeah. If you're a public figure, you're open to having crap talked about you. There's nothing you can really do about it unless you can show actual malice. Then we've got the Pentagon Papers, where Nixon tried to get the New York Times and Washington Post, try to prohibit them from publishing classified documents, and the court said, no, you can't do that, because the reason was too speculative. And that's prior restraint, going back to Walter from the Big Lebowski. Once they publish it, maybe then you can sue them if there's some sort of harm, but you can't tell people, sort of what not to say. Although as I say that, I realize that's a little vague. Hustler versus magazine versus Jerry Falwell. I remember this as a kid. I grew up in the Deep South, and so I remember, the pearl clutching over this, and people just, they just, they were making fun of him and Hustler, and he didn't like it, and the court said, nope, you can do that. That's okay, because he's a public figure. So we get to mock you if you're a public figure. These two parts are not used a lot, so I didn't put a lot here. But again, these sort of intertwine with other rights. An injunction to keep a white supremacist group from rallying violated the First Amendment. Edwards versus South Carolina said he violated students' First Amendment rights when they police dispersed a peaceful protest. And then I should have put the doctrine in here, but in that case, these are out of order. That sort of created the doctrine that is then applied in those cases. Okay, Second Amendment, another, fun, always controversy, all these amendments. A well-regulated militia be necessary to the security of free state, right of people to keep and bear arms shall not be infringed. Interestingly, all the big cases have come out in the last 15 years on this topic. I thought that was pretty interesting, that the right to bear arms was really sort of not a hot topic for a long time in this country's history. It wasn't pushed, or it wasn't a big issue.
Is there any basis or backbone to a well-regulated versus just buying arms? Does that figure in, or is that gone?
There have been so much written about that. I mean, they go back to interpret, if you're an originalist, you interpret what was a militia back then, and then they'll say a militia was everybody. So everybody gets to have a gun. If you look at it from a more, evolving standard, you say, well, that doesn't apply today. We don't have militias. That's sort of the fight, is over the definitions, of these terms. So, I'll skip over the first one. This was the first big one that was interesting to me. I think especially, I moved here in 1999. I remember reading about this case and thinking about it. We always heard in the West, I don't know if it's true or not, but you go to a saloon and you had to turn your guns in. That was the first thing you did when you got into town. You're a cowboy or whatever, you come into town, you turn your guns in. In Heller, so to me, there's a difference between having a gun in a compact city and having a gun, in the country, and obviously in this area, a lot of ranchers, people have guns. It makes sense. There's the police are further away. You've got bears, whatever, other things. So it makes sense that it should be different, right? If you're in a city or you're in the country. Go ahead.
Just talking about guns for a second, back in 1776, they didn't have a 30-round magazine.
Right.
So,
Right.
Yeah.
That's the problem. I'm not about guns.
Yeah. Yeah, it's just, yeah, and it's really, it's nuanced stuff. Yeah, I can't explain it right now either, but Heller was interested but that's sort of, the reason I was talking about that is because, yeah, in that case, so Chicago was trying to, manage their, gang wars, things like that. You heard about all the crime in Chicago back then. So they were trying to impose strict gun laws. And the court said, you can't do that. Basically you're no different than the country. And I thought that was interesting. If you're a Second Amendment supporter, I have clients charged for crimes. I'm going to use things like this to my client's advantage. It's the law. But it's interesting how all these important cases have come out sort of recently. Bruin, let's see. To justify regulation of that conduct, the government must demonstrate that a challenge law is consistent with the nation's historical tradition of firearm regulation. So like you're saying, I don't know how an AK-47 whatever, or AR-15 is consistent with our nation's historical tradition. But if I'm a Second Amendment advocate, yay. I mean, that argument works. And I put this last case in here because it's an example of defense attorneys. This case came out a year ago, and people in my profession are loving it because our clients are being charged. So if somebody's on parole, you lose your gun rights. You're not supposed to be able to possess a gun. What this case said is, even if you're on parole, you can have a gun because basically for self-defense. So if you're at home in your house, you have a right to possess a gun for self-defense. The government can't take that away from you, even if you're convicted of a crime. So people who are charged with possessing a gun in violation of their parole, this case is a great case because.
Is that true of people who have been sexually violent, have.
Yeah, there's other ways to, lose your gun rights. I mean, felons in Colorado, if you're a felon, you can't possess a gun. So, but.
Yes.
Domestic violence.
Right, the Lautenberg Amendment, right. But now, if you're a felon in Colorado and you've got your gun in your house, I think you've got a defense, based on this case.
And that all varies by state, doesn't it? The gun laws and gun rights.
I mean, I'm just doing constitutional,
Yeah.
so I mean, and states can sort of interpret their own constitution. I mean, this stuff tends to be, pretty consistent, I guess, is what I would say. But Third Amendment, I don't have cases on that because this is just, there's a couple of, interestingly, a couple of amendments. Obviously, we know why this one was made because the King George was using his soldiers, making them stay in citizens' homes. We didn't like that, so we made the Third Amendment. This doesn't really come up much anymore. I don't see much. Okay, now we get into my bread and butter as a defense attorney, Fourth, Fifth, and Sixth Amendment. This is one of my favorite amendments. It's what it's all about. The right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrants shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Government needs to stay the hell out of my house, my person, my paper, unless they've got a reason, unless they've got probable cause to invade my privacy. It's our right. It's a big part of our right to privacy.
My car.
Your car.
Car.
Yep. Olmstead, so that's a case where they.
Different
Yep.
Olmstead.
So federal agents were listening in on somebody's phone conversation. And the court held that the wiretapping target were not violated. So this wasn't a good case. Again, things develop. In this case, they held they could wiretap. But I love this quote by Louis Brandeis. Founding fathers conferred as against the government the right to be left alone, the most comprehensive of rights and the right most valued by civilized men. To protect that right, every unjustified intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. And eventually he was correct. I'll get to this case, Katz, that then overturned it. Matt v. Ohio, that's where police officers got a warrant to search somebody's home for obscene materials. And this is the exclusionary rule came into effect. So if the government violates your Fourth, Fifth, or Sixth Amendment rights, that evidence cannot be used. That was an important decision because the idea was we got to be able to punish law enforcement for abusing people's rights. How do we do that? We take that evidence that they seized unconstitutionally and we throw it out. So, cats, this is the one big case. So the Supreme Court ruled the Fourth Amendment protects people, not places, from unreasonable searches and seizures, specifically extending the protection to electronic surveillance. Cats, again, the opposite of this case in 1928, they used a wiretap, they got evidence from a public phone booth he used. So the idea is the Fourth Amendment doesn't apply to a place, it doesn't apply to the public phone, it applies to you the person. So your Fourth Amendment right, even if you're using a public phone, it's your right. That was a violation of his Fourth Amendment rights, even though it was in a public space. Terry versus Ohio, this is a case I use once a week. The court ruled it's constitutional for law enforcement to stop and frisk a person reasonably, I think that should say suspected to be armed and involved in a crime. Specifically, police don't violate the Fourth Amendment on reasonable searches and seizures when questioning somebody, even though the officer lacks probable cause. So what it did, it created reasonable suspicion. So you talk about a car, you do not have the same protection necessarily in your car as you do in your house. If somebody wants to get a warrant for your house, they need probable cause. If to stop you and when you're driving down the road, just need reasonable suspicion. So it's a lower standard, and I could get through all the rationale, but basically the idea is you don't have the same expectation of privacy in your car as you do in your house. So you can be, all an officer needs to pull you over. I mean, I do a lot of DUIs. It's the main crime in this town. Is a couple weaves, not using your turn signal. It's amazing. I see people every day not using their turn signal. Drive after 8 o'clock at night, you'll get pulled over. To me, that's not, there's a big, it's obvious law enforcement is, picking on people at night, and they're going to say there's a justifiable reason. I'm not condoning drinking and driving, defend my client. I don't defend, the crime if they're guilty, but to me, there's a different, it's amazing how, if you don't use your turn signal at 10 o'clock at night, you're going to get pulled over. Do it during the day if you're not. Just not using your turn signal is reasonable suspicion. So, use your turn signals. Especially at night, even, Mendenhall, so that's the free to leave test. So basically you are detained if you don't feel free to leave. So the three things that come up in my cases are consensual encounters, a Terry encounter, that's the reasonable suspicion, or a full seizure. And so if an officer comes up to you and says, hey, I want to talk to you, and you can walk away. You can say, I don't want to talk to you, I'm free to leave, bye, I'm not talking to you. And then if the officer says, no, you need to stay here and talk to you, you have just been seized. You were just seized under the Fourth Amendment because you didn't get to leave. And so he better have reasonable suspicion or probable cause if he's telling you that. If he doesn't have reasonable suspicion or probable cause, you get to walk away.
Does he have to describe that reasonable suspicion to you?
No, not necessarily. He needs to be able to describe it to a judge later. I think a good law enforcement officer will, because it's going to make you you're going to feel like you're not being targeted, if he'll say, I think smart cops do that. They say, hey man, I got these concerns, I saw this, I saw that. It's a good way for a good law enforcement officer to sort of de-escalate. And, to me, if you just come up to somebody and say you can't leave, the person's a lot less likely to talk to you, and a lot more likely to say, to invoke their rights. So.
And you said police officer, and that's completely different. That's like a criminal, they're looking at criminality versus, in my mind, I'm thinking ICE officer.
Right.
And civil, do they need that same description or probable cause?
Just, I wish I could answer that. We know, I think the one thing we know is they need a warrant from a judicial officer. So I think they need probable cause. I think they need probable, but see, that's a really good example. Let's say you're not here legally and they come up to you and you don't walk away and they start, hey, how you doing? What's your name? And I don't know, maybe even just you can't speak English. Or where are you from? And or something. What they're doing is they're developing probable cause. That's why you don't talk. That's why you walk away, because they want to get people who are too compliant. People who are like, oh, I'll just explain, officer. And the more you talk, the more you're digging a grave. You know, you're digging a hole because that officer is now developing probable cause. He didn't know the name of, you know, he couldn't speak English. He didn't know the name of the city he was in. He couldn't tell me where he was coming from. You know, they'll start using this stuff, and that's why you don't talk. And because that puts the burden on them, because then if they're going to detain you, they better have probable cause, you know, and so.
Flip it and say, well, wasn't talking to me, but that was
No.
suspicious.
No, silence, that's a good question. Yeah, silence cannot be used in that situation. No. Yeah.
So you know that in criminal law, that a policeman can tell you, you need to stop and talk to me, and you legally have to stop and talk to them.
You do. I
But
would,
it's still, your best course is to not say anything.
right, and so with that, yeah, well, I would, because you're not, because you want to preserve it for the attorney. So the attorney can win it in court later. And so, if a cop comes up and says, you're detained, you're gonna be better off just standing there, not saying anything, and then fighting that in court later, as opposed to maybe running or doing something that's gonna then create more probable cause. Although there are cases that say fleeing doesn't create probable cause. It's nuanced, but you're better off, that's what you get an attorney for, is don't. There are just cases in Denver though, where, for example, person of color ran and the court said you can't use that. It's not against that. But then there are cases that say you can. It sort of depends on, like, one thing's like a high crime area. So like if you're in a prostitution area or like a drug area, they can sort of use that against you. But then there's people who are poor. That's where they live. You know, I live in a poor high crime area. So just because I live there, suddenly I have fewer Fourth Amendment rights, you know, it's not, that's sort of the way it is. I mean.
And that's what I wonder too, as far as improbable cause, if you're a brown person. I mean, because then that's a racial profile.
Yeah, I don't think your skin color, I don't think that can be used. I don't think, I don't think that per se can be a reason to develop probable cause. It's what?
It goes back to the.
Yeah, the idea that everybody who's a certain color is here, illegally that's kind of far-fetched. I mean.
But isn't that racial profiling?
Yeah.
They just use colors.
But they can try. So they can walk up to a bunch of people, dark skin, they hear speaking Spanish. If those people are smart, they're gonna say, bye, walk away. But what they're gonna do is they're gonna get the ones who stick around and start talking, like, hey, how you doing? And they'll think, because in their country, they don't have a constitution. Then the rule of law is not as strong. In their country, you schmooze the cop, you give him a couple bucks or something. That's how you get out of it. So they don't come from that culture that we have, where we as Americans know, cop comes up to me, I don't have to fucking talk to you. No, bye, go away. If you're going to talk to me, arrest me. But we have that courage because that's where we were raised. I mean, being in a foreign country, that's asking a lot of somebody. But, you have to be pretty courageous to be from a different country and tell a law enforcement person to, go pound sand. I mean, I think most people think I can just talk my way out of this or something.
I ran across this the other day and it's a sign you can put in your window. It says, I remain silent, no searches, I want my lawyer. Please put any ticket under the window shield or under the windshield wiper. I am not required to sign. I am not required to hand you my license. Thus, I am not opening my window. I will comply with clearly stated lawful orders.
I think that there is on stage.
And I think, we're gonna get to a case I'm gonna throw a little wrench into that. Because
Okay.
I generally agree with you. And, but what if they stopped you for not using your turn signal? Then it changes. Then you can ask people, because then there's a crime. So, you're in a car and, you didn't use your turn signal, suddenly that's not gonna work. And that could make things work. I mean, I don't know. I don't know that it could make things worse necessarily. I still think that would be maybe the right advice, but, they're gonna be able to get you out of the car. Yeah. Let's see. When I was a public defender in Grand Junction, this one came up a lot. Florida Plea Bostic. You're on a bus, cops come on the bus, and say, we want to search your bags. Would you feel free to decline the encounter? And the courts have said it's okay. You can do that. So, but again, you're on a bus, cops come on the bus, hey, we want to search your bags. I think a lot of people would not feel comfortable saying no. A lot of people would say yes. So
But you're saying that you can say
you
no.
can say no, you can say no. And sorry, Martha, I know I was gonna try to make this shorter than an hour. But that's not having luck with that. So let's go to Fifth Amendment. This is your due process. Here's your due process. It used to just apply to the federal government. You can't be held to answer for a capital, otherwise infamous crime. The important part is here at the end. Nor shall you be compelled in any criminal case to be a witness against yourself, nor be deprived of life, liberty, or property without due process of law. Those are great words. You can't be deprived life, liberty, or property without due process of law. So that then became the 14th Amendment.
So know that applies to everybody, including non-citizens, because it just says person?
I think so. Well, I think it starts from that premise that the Constitution applies within our borders. It doesn't apply to, necessarily the person. It applies to everybody within our borders.
It
So,
doesn't say citizen, it says person.
so just the double jeopardy, this is the Blockberger test. This still comes up in criminal law that you can, as long as the two laws just have a different element, you can be charged with two different crimes. So as long as, the two laws are just a little bit different. There's just a little bit different fact. You can be charged with two different crimes. The big case again, Miranda, we all have heard of that. We've all seen the TV stuff, this TV shows where that comes up. You have to be advised about your right to silence before law enforcement can question you. I had a hearing today at 3 about this. Got continued, but the issue was custodial interrogation. Are you in custody? Are you being interrogated? If those two things apply, they have to give you Miranda rights. They have to advise you of your right to silence. If you're not in custody, some people like DUIs all the time. People, hey, they started talking to me. No, you weren't in custody. You're just standing there by the side of the road at that point. It's a Terry stop. You're not in custody. Miranda doesn't apply.
Terry stop.
That's that case that said all they need is reasonable suspicion. So just you not using your turn signal, cops can stop you. You're not being detained. They don't have to Mirandize you until they put the cuffs on you or until you're not free to leave. Let's see. Yeah, here's the case I was talking about. It sort of conflicts with the not rolling your window down. They had a statute requiring suspects to disclose their names during a Terry stop. That doesn't violate the 4th Amendment. If it first requires reasonable suspicion of criminal involvement, doesn't violate the 5th Amendment right to self-incrimination. So if you're in a car, you don't use your turn signal, they stop you, you then say, I'm not going to roll my window down, they might be able to break your window, and pull you out because you didn't use your turn signal. Now, if they just pull you over, you haven't committed a crime, don't roll your window down. That stuff works. But if you even committed a traffic offense and you say, I'm not talking to you, officer, they can then break your window and pull you out. So
Because they could pull you over because you're
right,
left, brake light.
right, exactly, right,
But you don't know what it is yet.
right. I just put this one in because this is eminent domain. This person tried to acquire their house. And the court said, yes, you can do that as part of a comprehensive redevelopment plan because under the takings clause, the test is that the general benefits of the community would enjoy from economic growth qualify as public use. Again, this whole treaty is written on eminent domain and things like that. 6th Amendment, only time I highlighted something in red because that's my job. I gotta be proud about that. And hey, my job is in the Constitution. I don't know, that's pretty cool. Why I like my job? Yeah, I mean, who else out there? Hey, there's a specific amendment for my job. All criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, impartial jury of the state in which they were committed, informed of the nature and the cause of the accusation. You can't just hold people without reason. You have a right to know what you're being held for, confronted against the witnesses against them. I get to obtain subpoenas, to obtain witnesses, and to have the assistance of counsel. Very, very important. The landmark case, all defense attorneys sort of like our shrine is to Gideon versus Wainwright. This was a guy in Florida He was being held. He kept writing to the judge, I want an attorney, I want an attorney. Judge kept denying it, got all the way to the Supreme Court. The Supreme Court said, yes, if you're indigent and in custody, you have the right to a free attorney. That's why we have public defenders. Colorado actually has one of the best public defender systems in the country. It's renowned for having a really good public defender system, and it all stems from Gideon versus Wainwright, a very seminal case.
That applies to criminal law.
Yes, right.
So are the people that ICE is detaining, are they charging them with a crime? So do they have a right?
I think those are kind of civil. I think some of those are civil. So that's the thing. You don't get an attorney.
Offense. Are they taking people with the civil offense and sending them to Sudan and El
Yeah.
Salvador?
Well, they don't have the right to an attorney, so they get to go in front of we've heard about these like 5-year-olds being taken in front of immigration judges without an attorney. Seems crazy, but the idea is it's not criminal, so you don't get the right to an attorney. So this like 4-year-old is, sitting there in court in front of an immigration judge. It's pretty crazy. Crawford v. Washington, that was about the confrontation clause. So if somebody is making an out-of-court statement that's testimonial, you have the right to confront that person. So a lot of times, again, DUIs aren't a big crime here. Somebody calls in a ready report and says, this person's drinking and driving. It's interesting. When I first started practicing here, a dispatch would talk to them about that. Now, dispatch, one of the first things they will say to you when you call in a ready report is, are you willing to testify? And the reason they're saying that is because that makes the statement testimonial, and it gives that statement a little more power. If the person says, I'm not willing to testify, it can be considered just sort of a weaker statement, and it can't be used as well. So dispatch has been trained to ask people that question because there's a lot more I can explain, but it basically defines what is a testimonial. Domestic violence cases, it comes up a lot. Somebody will make a 911 call, there's something happening. They're talking to the person and they're describing what's happening. And if what they're describing is sort of something you would testify to, then that statement, that person has to come into court to hit the person. If what they're saying is like an excited utterance, like he's hitting me, she's hitting me right now, that can be admitted without the person having to come into court. A lot of nuance there. Sort of depends on how the statement is made. Strickland v. Washington established the ineffective assistance of counsel. So, as a defense attorney, I have sort of minimum duties, and you have to show that my performance was deficient. Barker v. Wingo's v. trial right. Batson, that's a big one. You used to be able to, if you're a prosecutor prosecutor, you're trying, let's say, a black man for a case. You've got, black people in your jury pool. The prosecutor used to just be able to strike them. You'd strike people of color for no reason. Batson said you can't do that. You have to give a race-neutral explanation for kicking this person off the jury. And that case has now been applied to defense attorneys. So it used to be, up until very recently, as a defense attorney, I could probably kick people off, people of color, without reason, without providing a race-neutral reason. Now that applies to me too. So you cannot kick people off a jury without providing a race-neutral explanation. Seventh Amendment, not going to touch this one. Another one that's just, Eighth Amendment, excessive bail, cruel and unusual punishment, couple of cases. This is a really interesting case because it did come up in my homeless cases. Powell v. Texas. So Powell was an alcoholic. And the court had criminalized being drunk in public. And so the idea was you can't discriminate because that's immutable. I'm an alcoholic. I can't help it, right? I mean, it's not, you shouldn't be criminalizing it. And the court said, well, you're not criminalizing the condition, you're criminalizing the act of him being in public drunk. And so the court said you can criminalize being drunk in public.
Even if they're not harming anybody?
Yeah, and even if you're genetically predisposed, you're an alcoholic, it's, something like that, if you're committing a crime in public, that can be criminalized. Then, death penalty was unconstitutional for a while. Then it got reconstitutionalized. That's sort of what Furman's about. But it is unconstitutional now to execute people who are under 18 at the time of the offense. So what's interesting about the Eighth Amendment, it evolves. It's one of those few that evolving standards of decency. So, you used to be able to haul and keel people when our Constitution was passed. You wouldn't get away with that today because you can't, because it is evolving. Ninth Amendment. So yeah, here's some interesting cases. I put these here because they really they can go under the 14th too, but I needed something for the Ninth Amendment, and I didn't actually realize that was part of the analysis. Certain rights shall not be construed to deny or disparage other rights retained by people. That was the right to privacy. The right to privacy is not listed in the Constitution necessarily. The Ninth Amendment, it was sort of used to create Roe versus Wade. Griswold versus Connecticut, that was where they were criminalizing, I think, contraception. They were criminalizing contraception. Both of those cases rested on the right to privacy. The right to privacy in my, bedroom at my house to, do what I want. 10th Amendment, gonna kind of do that one fast, not a lot there. Okay, we're almost there. Let's sort of start going faster because, now we're out of the Bill of Rights. These remaining amendments don't come up as much. 11th Amendment, that was judicial power, shall not be construed to extend to any suit, law, and equity commenced to prosecute citizens, but I honestly don't know what that means. I'm not sure what that one, I don't think I've ever seen the 11th Amendment in a case. I don't know. The next three, what's interesting about the next three, these were the post-Reconstruction amendments. So these three were published after the Civil War. It changed how the electors and the president are chosen. 13th Amendment, slavery, obviously one of the biggest post-war amendments, neither slavery nor involuntary servitude, except as a punishment for crime, where the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. So that's, that one doesn't come up much anymore either, because it's pretty black and white, no slavery. The biggest one, the 14th Amendment. So this is the last one I'll sort of spend some time on, sort of the last important one. So remember the Fifth Amendment, the due process, right, liberty, property, due process of law. Prior to this, that just applied to the federal government. So the states could mess with your due process. As long as it wasn't the federal government taking away your, life, liberty, those sort of rights, the states could do whatever they want. The states could discriminate. This made the due process clause applicable to the states. So now due process doesn't just apply to the federal government, it applies to states. Very, very big decision. Almost every big decision nowadays touches on the 14th Amendment. And you can see the part I underlined here. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction equal protection of the laws. That equal protection clause, that's what I use in my homeless cases. Made due process applicable to everybody because, the southern states were going to still discriminate. They were still going to, terrorize Black people, and the purpose of this was, no, you're not going to do that. It applies to the states too. I believe that's why that's a good question. I want to say like the 1870s, 1860s, 1870s.
Before 1920.
Then they've got section 2, all this stuff. I'm glossing over this because I don't know, the vice president, how you elect them. What's interesting about this is the part at the end. Okay, so this changed the voting age to 21. So it only applies to men, over 21, citizens of the United States, unless you participated in a rebellion or other crime. The basis of representation shall be reduced in proportion to the number of such male citizens shall bear the whole number of male citizens. So I think what this was doing was, it wasn't disenfranchising those who participated in the Civil War, but I think it was saying if you rebel at a future Civil War, think about those January 6 guys. I don't know. I think the argument is under this that they can't be counted for the census. I don't know. I'm getting way off.
Wasn't that about black people only counting as 3/5?
Well, that was prior, so yeah, that's what this changed, is, yeah.
Including.
That, right, that's what changed this, and all men over 21, notice it doesn't say black or white, so,
Nor
Yeah.
does it say women.
right, so black men, this gave black men the right to vote. Black men got the right to vote with this. Women, hold on, I'll get there. Still behind the, yeah.
16 more years.
Yeah, right, yeah, it's just, the rebellion stuff is interesting to me, I never really noticed that about it, so, yeah, the part I hear in section 4, but, so this was the part, so the federal government didn't take on the debts of the southern states. So if the southern states had contracted with, let's say, another sovereignty, England, the US was not responsible for their debts. Yeah, so here you want to talk about development. 1896, we had separate but equal. It's okay to treat people differently as long as it's equal. You can have, the black train car, you can have the white train car, as long as it's equal, everything's fine. Brown Board of Education. This one really, I get fired up about this stuff. So I grew up in the Deep South. The first school I went to in Holly Hill, South Carolina, believe it or not, this is in the 70s, had 2 classrooms. One was all black, the other classroom was all white, had a couple of black people in it. So this is in the mid-70s, de facto segregation was still going on. And what the other interesting part about this is there was another case that went with Brown. It was called Briggs. For some reason, Brown got when they were docketing them, Brown got the name. There were actually like 5 cases. Briggs, I lived in Florence, South Carolina. Briggs was from nearby Clarendon County. And they, along with Brown, filed suit because the white students were given all the money for buses. The black students didn't have any money for buses. The elementary school I went to was Briggs. So the elementary school I went to was named after that case. It's really interesting. It's just sort of seeing that in person. It's yeah,
How
interesting.
in the 70s did that? Because the Equal Rights Amendment was not equal.
Well,
Civil rights was 1960s.
It's amazing, yeah. Well, I think the way they did it was because there were a couple of black kids in the white class. So, and this is the part that's just really crazy. I think they did it they said it was not based on intelligence. I mean, as we all know, that's bullshit. But they said this class is for the less smart. This class is for the smart kids. Purely coincidence that the less smart kids are all black. The smart class is basically all white kids and 4 black kids. That's how they did it.
They
Yeah.
continue to segregate the kids with disabilities. Relevant to the next.
Yeah. Did you see there was a great PBS documentary like a couple months ago on the passage of that was inspiring, seeing how that got passed in the 80s. Really interesting stuff. Loving versus Virginia. What a great name. I mean, what a great name. You can't marry a white man and a black woman cannot marry. Anti-miscegenation laws, however you say it. Struck that down, said you can't, that violates the Equal Protection Clause when you draw a distinction based on race. So again, we go back to those standards. That would have been a strict scrutiny because you're discriminating based on race. If you're going to pass a law that says people can't marry, you better have a damn good reason for trying to pass this law. The Virginia law didn't meet that standard. And then we have Obergefell versus Hodges. That was the seminal gay rights case that said gay marriage is a fundamental right deeply rooted in this country. If rights were defined by who exercised them in the past, this was Ginsburg writing. Were defined by who exercised them in the past, then received practices could serve their own continued justification, and new groups could not invoke rights once denied. So in other words, just because it used to always be that way doesn't mean it's still that way. That's a terrible reason to do something. Just because it's always been done that way doesn't mean it still has to be done that way. But that's a great picture. I mean, that's sort of like, doesn't that pull at your heartstrings? Like, I mean, that's love, you can't tell people not to, the idea that you can criminalize love is just, It's crazy, but it was a law until 1967, right? I mean, we're getting better, people. I know it feels like right now we're not, but slowly but surely we're getting better. 15th through the 27th amendments, yeah, I know, I feel a little disrespect being here, the League of Women Voters, that I did sort of just, just put the 19th Amendment in there, like, hey, 19th Amendment, it's a really, really big deal. But these are ones that really don't get challenged much, they really, there's not a lot of cases on them. They don't get challenged. Basically, you can't deny the right to vote based on race, color, or the fact that you were a slave. Income tax, this is around the 20s. That's when income tax finally became legal. They changed senators. I think before it was 4 years. Now it's 6 years. Prohibition was against the law to drink. And then there we go, suffrage. Suffrage. Interesting too, in South Carolina, I had this 4th grade teacher who was all about women's rights. I learned more about suffrage than, I don't know, I think most people, because she spent like 2 weeks teaching us about that amendment. You think about, I have this love-hate relationship with the South. I don't live there anymore for a reason. I'm not a fan of some things, but there are people, there's it's pretty remarkable people who can exist in places where ignorance is still kind of prevalent. Suffrage was passed. So now, before Black men got the right to vote, now Black women and white women have the right to vote. 20th, about who succeeds if the president dies. 21st, now you can drink again. We're in the Depression. We need to drink. Come on, people. There's depression going on. Repeal that. We need to drink. 22nd, president was limited to 2 terms. So again, the president we have today is doing this stress test. He's pushing these boundaries. Let's not forget, FDR kind of did the same thing. I mean, he served, but before FDR, there was just sort of this implicit agreement. You don't run more than twice. FDR, he pushed it. And our response was to pass an amendment that says you can't do that. No more than 2 years.
War related, like it was right in the middle of World War II, and they just.
Yeah, I mean, that's why he won. But the idea is, I mean, even if we're in a war, you should be able to run, for another term. No poll tax, again, in the South, what they were doing was charging people to vote, said you can't do that. Presidential vacancy, voting age, remember that, I think it was, the one that gave the right to vote. Right, now it's saying down to 18. 18, that's one of the most recent ones. And then the last one, compensation of Congress. They get paid. All right.
Take it away.
Oh, wait, my last one, just because Martha asked me about this. I didn't know where to put it. Okay, last thing, posse comitatus. Okay, so this was another post-Reconstruction law. Because the Ku Klux Klan was going around terrorizing former slaves, and so they've passed this that said you can't use state law enforcement to help with the federal government. As I'm saying that out loud, I'm not exactly.
The military.
Yeah, you can't use the military.
So domestic issue.
Right. Thank you. Yes, that's pretty much it. So I'll tell you, like in my practice, was this they'll come up with is drug cases. So the DEA will come in and try to go after my clients, and they'll use the local sheriff to go after them. And so clients think, well, posse comitatus, man, you can't use the local sheriff to prosecute me. No, doesn't work. But that's where you see a lot of defense attorneys. That's where it comes up a lot nowadays, is people will argue that if the local sheriff does something in conjunction with the federal government, it violates posse comitatus. I think in general, I haven't seen that work. I haven't, but you can do that. You can work with the local sheriff.
Wasn't that the issue they were talking about with this administration sending the military to California?
Well, look at the next thing I've got. So this is, I learned a lot from doing this. You know why Trump's doing DC first? Because it's like the exception. Yeah,
what's that again?
That's the thing. I mean, he's got people working for him who are smart, who are really, they're going through this Constitution, kind of like, word for word, right? And they're picking at things, and they notice, oh, you know what? you can use, the posse comitatus doesn't apply in DC. It doesn't work there. So we're gonna start with DC. We're gonna start with DC. Then they're gonna get their footing and they're probably gonna try it in a state and then, I don't know, but, one of the loopholes is that because remember, the District of Columbia is under federal rule. And so, so if you send the National Guard in, you're not messing with the state, you're messing with the District of Columbia. So, yeah, I thought that was really interesting. It sort of, the light bulb went off, like, now I understand why he's doing that. He's got, say what you want about him, he's got people working for him who are, they're stress testing our Constitution. They're pushing and they're finding it, and it's really scary for us right now, but, 100, 200 years from now, we're gonna have laws that hopefully clarify this, and they're gonna look back and go, man, I can't believe, kind of like Plessy versus Ferguson and all this stuff. They're gonna look back and go, I can't believe you could do that. And the reason it's not gonna be illegal in the future is because we lived through it, we fought it, and we exercised our rights.
So, native sovereignty is federal. So, but it's also sovereign. So, but is there any room for, say, an administration to push, the militarization into our federal tribal lands through this kind of legal avenue?
So that, yeah, I did. I thought about putting into that. I felt like I had enough here, but I was going to kind of research that. There's something really interesting in, the presidential proclamations that Trump made. One of his things was he is now under the guise of fighting the drug war. He specifically listed reservations. Yeah, and I thought that was really interesting. I don't know if a lot of people caught that, but if you go back and look at his proclamations, he lists like borders, which makes sense. People are importing drugs at borders. Then he lists Indian reservations. And I think that's why he's doing that. I think he's trying to, right. And he's doing, because there's no drug war. Whatever. There's drugs on the right. Yeah, there are. I'm not saying it's like, yeah, there are, but it's not a border. It's not, drugs aren't being imported through reservations. So
it's not like, like say, because I'm Southern View, so it's to say like, oh, there's this big Southern View cartel.
Right, right.
Working with other.
Like Mexican cartels, right? So I think he did that he's chipping away, he's trying, because he wants to federalize Native American land and
even attacking other citizens or not.
Right. That's what I mean. There's that whole analysis, right? It's some law, and it's like from the 1910s or 11 that made, Native American citizens, but it's it was through an act of Congress, I think, and so it's sort of susceptible to challenge. Like it's not as solid ground as some of the other stuff, and so. But yeah, okay, that's probably yeah. So he's yeah.
He's somewhere already stated he wants to challenge that they're not sovereign.
Right. Right. No, because when the Constitution was founded, Indian reservations were not part of. They're specifically exempted from,
naturalized citizens.
from jurisdiction. Yeah, basically.
So not a naturalized citizen, so to speak.
Right. But then the law was passed that was supposed to rectify that. But the way it was done sort of leaves a little crack in there. Right.
It's
right.
Vague.
Vague, yeah.
Yeah. So. Yeah, because if you're going, because a reservation, if you're not, it's not specifically a state or yeah. Okay, thanks, guys. Yeah, appreciate it. Yeah.
Thank you, Brian.
Yeah, thank you for having me.
Wow, this is really good. Thank you.
Just one.